Welcome to Looking at Legal Stuff. Today we have 8 hearings in the case of a couple where the wife is making multiple attempts to get some sort of support from her ex-husband, claiming he supported her for 20 years and now she's become 100% disabled. She'll need for him to continue to support her. Despite the fact that they had reconciled and are now splitting up again, the husband's lawyer claims that their separation agreement from 2008 is still in effect, and that agreement barred any kind of spousal support. The wife then tries to hold the husband in contempt for not paying any kind of child support that was ordered in that 2008 agreement. She wants him to have to pay her the support ordered in that judgment, despite the fact that their youngest child turned 18 over 6 years ago. Will she be successful in her bid for support? Let's find out.
I take number 12 on the docket, 24-312-08, Fragel and Fragel. I don't know if I'm saying that correctly. I apologize if I'm not.
I believe so, Your Honor. Megan Gilmore on behalf of the petitioner and non-moving party, namely Timothy Fragel.
All right, and
Marcella Renee Fragel, respondent.
thank you. Just a second here. I didn't say it, 24-312-08. So I wanted to find out what in particular was going on with this matter. I did not see a response. Looks like there's new counsel, so just wanted to see where things are at.
So we were before the court on the 14th for trial assignment. Judge Carmi at that point set it on today's docket. My staff filed a responsive declaration on Thursday. We did present a bench copy, but I know that there's been some issues with bench copies. And so I do see that it's on Odyssey, but it's not uploaded. So the court hasn't had the opportunity to receive that. The motion frankly wasn't timely even for today's hearing, so we likely need to set it over.
Okay.
Ms.
Ms. Fragel, anything?
Yes, that gives him more time to pack my things and ruin them. And I don't believe it should be set over because it causes me undue hardship.
So Ms. Gilmore, I do have some concerns. One, I do think it's appropriate to go ahead and set it over. I understand what you're talking about, Ms. Fragel. But meantime, Ms. Gilmore, I do have concerns in regard to the allegations and what's being said here. And I want to make sure that there is I want a restraining order in place at this time, that there's no disposing of, no selling, hiding, the usual, and no damage or destruction of any property of anybody. Either party until this matter can be heard.
Absolutely, Your Honor, I understand.
Okay, so with that, what are you thinking? I guess you already filed your response. Ms. Fragel, you'll probably want some opportunity to respond too. Do you want to set it over a week or 2 weeks?
1 week would be easiest for me, Your Honor.
Okay. Ms. Gilmore, does that work for you?
Yes, I'm already before the court on other matters.
Okay. All right. So let's go ahead and set it over 1 week to February 27. And that will be at 9 a.m. And I'm hearing somebody in the background. Okay, I'll set it over to February 27 at 9 a.m. and we can hear it at that time.
Thank you.
Okay, thank you. Thank you.
Okay, going to number 13, 24-3-12-08, Fragel and Fragel.
That matter is ready, Your Honor. Megan Gilmore on behalf of petitioner, namely Tim Fragel.
Marcella Renee Fragel, currently present.
Thank you. All right. So I have a motion for order for leaving respondent's property alone. I've read through everything, and for some reason I am missing. I'm going to be right back. For some reason the notes are missing out of my file, but so I will be right back. Okay, so I apologize for the delay, but with that, Ms. Fragel, are
Yes,
you there? Okay,
yes, I am.
all right. And Ms. Gilmore,
Yes, I'm still present. Thank you.
okay. All right. With that, in regard to the motion, I've read everything from you, Ms. Fragel. I don't need to go through everything that you wrote. Is there anything that you wanted to add?
No, Your Honor.
Okay, Ms. Gilmore, I've again read what the response is. Anything you wanted to add?
No, really just in summary, my client agrees to the standard prohibitions on property, moving, selling, hiding. We mainly are just looking for a remedy here so that we're not before the court again on another issue. I think that the remedy would be moving the property out into a storage unit. She then accesses the storage unit or keeps the storage unit. Alternatively, we set another civil standby so she can access the property. My client just can't continue to live under the current conditions that she was living in the house, and we are just trying to remedy this issue so we don't have to seek any more court intervention.
So,
Your
Ms.
Honor, I object to that.
Okay, so Ms. Fragel, what about a standby of going in and getting your things?
I am not restrained from the home, Your Honor. I don't need a standby. I just need to be able to get into the home.
Ms.
She's
Gilmore?
restrained. Sorry, Your Honor. It's my understanding she is restrained from having any access to my client's residence, his location, etc. My client has previously agreed to an exchange of property through my client's brother, which he'd be willing to do so. Again, I guess we just need a clear understanding of the property she wanted to access. So that's not a problem for my client. We are willing to facilitate that.
So if there's a restraining order in place, Ms. Fragel, it would require a standby for you to go to the house.
But I am not restrained from the home. I am only restrained from Mr. Fragel.
Okay. Without seeing the order, I can't tell you. So bottom line is, I want it understood, I'm not here today to decide which person gets what. This is a request for temporary orders. And so with that, I'm not going to get into the whole, this person gets this. I understand, Ms. Gilmore, what you're talking about, but I think you're going to have to bring your motion and show the stand or restraining order, because I don't see it.
Okay, if you would like me to do that, it's just a little difficult because the property's throughout the house. But maybe we can coordinate amongst ourselves. I mean, like I said, I understand the normal prohibitions on property. I'm not going to advise my client, obviously, to move, hide, sell, damage. He denies doing so. So I guess we'll just have to deal with it moving forward as we progress the case. We do have a settlement conference set up for, I believe, April. So hopefully we can get this resolved.
Okay, so at this point, neither party is to move, take, hide, damage, borrow against, sell, or try to sell or get rid of any property unless it is a usual business practice or to pay for basic necessities. Both spouses or domestic partners must notify each other about any expenses that are out of the ordinary. Also, neither party is to open, dispose of, delete any mail, be it email or regular mail. Okay, so that's what I'll order. Ms. Fragel, it will be up to you to get an order, or Ms. Gilmore, can you prepare a standard order and get it to Ms. Fragel?
Yes, I can do so.
Okay, so Ms. Fragel, Ms. Gilmore will get you a standard order. That's standard language in a lot of temporary orders. And that way we can get that into place, okay?
Thank you.
All right, so I'll go ahead and set this on for a presentation. Let's see, we're on the 27th, for March 12,
Okay,
and that'll be at 9 o'clock. And that way Miss Gilmore can get an order prepared. Okay.
and what is the presentation on March 12th?
It's just to get an order to put this, what I just ordered, into place. It needs to be reduced to writing. And
Okay,
Miss Gilmore is going to go ahead and do that.
thank you,
All right. All right, that takes care of the matter for today.
thank you.
None. Want to take number 7 on the docket, 24-3-00012-08 Fraggle and Fraggle. We have Miss Gilmore. Do we have anybody else present on that matter?
I'm here, Your Honor, Marcelo Renee Fragel.
Okay. Ms. Fragel, I did not see any response from you as to any objections.
It's an
To-
agreed matter, Your Honor. I just couldn't sign it at the time.
Okay. All right. So with that, so if I understand correct, I seem to get a feedback here. I don't know what's going on. So you're in agreement with the proposed order? Okay.
Yes,
All right. With that, I'll go ahead and sign off. And Ms. Fragel, are you okay to put approved via Zoom?
yes,
All right, that takes care of that matter.
thank you, Your Honor.
Going to take Fragel and Fragel, cause number 24-3-00012-08.
That matter's ready, Your Honor. Megan Gilmore on behalf of petitioner and non-moving party, namely Timothy Fragel, excuse me.
All right, can you pull that mic right in front of you and just counsel so you know that she's present here in the courtroom, Ms. Fragel? All right. All right, these are your requests. So it's your opportunity. Do you want to add anything to what you had?
In my second declaration where I was saying that he was lying on his financial declaration, I do have proof of that.
Okay. If you haven't filed it by now, I
It
can
is filed.
consider it is filed. Okay. When did you file it?
I believe about 2 weeks ago.
Okay, the financial declaration?
Yes.
Okay. Okay. Anything else you want to add to your statements or
No.
argue from your statements?
No.
Okay. All right, Ms. Gilmore?
I'll keep my argument relatively brief. The parties were married on July 13th, 1997, and separated for a final time when their legal separation was finalized in Oregon on June of 2008. Within that order, the duration of the legal separation is defined as unlimited. The order specifically states that neither party is to be awarded spousal support. This was prepared and agreed by petitioner of that action, but wife in this case. Respondent is now precluded from asking for spousal support especially on a temporary basis, without the court making a finding regarding the legal separation order after 16 years after the legal separation was entered. A decree of legal separation is a final order, and it is not interlocutory. Under the case of marriage of Moody, and I can provide the court the site of that, the court held that reconciliation does not invalidate a decree of legal separation. Therefore, it remains enforceable and in full force and effect. We do ask the court to deny the request for spousal support based on the lack of standing in the previous order. Moreover, respondent fails to present anything in her underlying motion to support her claim for a need of support. We have one pay stub that was submitted within discovery. She's provided no financial information on her behalf within her motion supporting her request for a financial declaration within her underlying motion. Through discovery in this very short turnaround case, we still haven't received any bank statements or other information outside of, again, one pay stub provided. She also makes argument in her reply that she's not receiving Social Security based on a need rather than insurance. However, she does include in her declaration that the fact is that if she does receive spousal support, her benefit would go away, which suggests to me that in fact it is SSI rather than SSD. And she's relayed to the government that these parties have been separated because my client's income would be contemplated. So she's been benefiting since 2012 that these parties have been separated.
Your Honor, that's not true.
Stop. Go ahead.
I think it's also important to note that she claims within her financial declaration that her rent's going to be over $2,000 a month. However, in her actual declaration, she notes that she only pays $350 for rent. We provide in our materials, the respondent has clearly a ability to make ends meet as she's going on trips to Mexico and the like, where my client doesn't simply have the ability to do so. As to my client's income, he has a gross annual income for 2023 of $87,775. I divided that by 12 months, which gave him a gross of $7,314 or net of $5,070. My client recently was injured and likely estimates to be out of work for another 6 to 12 weeks, which is similar to what happened last year when he was receiving short-term disability and was out of work. My client is going into the negative each month based on his financial declaration alone. My client simply does not have the ability to pay support, and we don't believe that wife established a need. So we do ask the court to deny spousal support. Looking to some of the other requests, we do ask the court to deny respondent's request to access the home. As the court's aware, the court in another action entered a DVPO that protected my client against respondent. I won't go into the details of that, but mainly regarding concern of respondent's mental health and her threats of violence to my client. My client has remained in the home since this action has been pending, and we ask the court award him the home on a temporary basis. We ask that respondent does not have access to the home and remains within 500 feet of the home, similar to the restraints within the restraining order. There's ongoing issues regarding personal property, and I believe that that is the basis for the request of access to the home, is she wants some of her personal property, which my client has been happy to facilitate. However, she continues to fail to exchange it. My client indicates in his declaration that he's more than willing to even pay for a storage unit in the interim to facilitate this so that wife can have access to her personal property. But again, it just simply does not make sense that these parties have equal access to the home given the restraining orders and the previous facts of this case. So we do ask the court deny spousal support, deny wife's request to have access to the home in order that she pays her vehicle, which she has been doing since this case has been pending.
So Ms. Gilmore, is the protection order still in place?
No, it was extended through April. My client, because there was no contact or violation of that order, he decided not to extend it. So that is why the issue is before the court, is because the restraining order has lapsed, which would technically allow her access to the home, but for my client residing there.
All right. Any response?
Yes, he said that I had put down 350, which is what I'm currently paying. When I did my new financial declaration, I made it for what I would have to pay after our separation. So that's the discrepancy. I did list 8 different apartments with the medium being $2,070 per month. The restraining order has lapsed. And as far as when we were separated, since then, I have become 100% permanently disabled, and him has taken care of all of the bills and all of our needs. Regardless of whether he was hurt, he is getting disability of some kind and therefore has the ability to pay. He's making a lot more than what he said he was in his financial declaration, as proved by his pay stubs, which you have. There is no reason for him not to pay child or spousal support.
So Ms. Gilmore, in regard to the legal separation, that was done in Oregon, is that right?
Yes, Your Honor.
Okay. And did you file any part of that? Because I don't recall seeing it. when
I
did,
did. I filed the entirety of that. Wife had only filed a portion, so we had filed that with the court. I'm looking, sorry, give me 1 second. That was April 9th, 2024. It just references general
oh,
judgment.
here
of
it
some-
is. Never mind. Yeah. I missed it yesterday when I was trying to find it.
And I was referencing, I believe, which was page 9 within the PDF, but the page is 8 on the form, referencing that the legal separation duration is unlimited.
Your Honor.
Just a minute. So I'm looking at under paragraph 11, page 7, it says no spousal support or spousal life insurance is ordered in this case. So, and then, and then what was the other page that you said, Ms. Gilmore, you were looking at?
It's that, yes, it's under, like I said, the PDF is 9, but on the section, it's section 17, page of the order 8, and it says the length of
Oh.
separation shall be unlimited.
So my question to you, Ms. Gilmore, is this is a legal separation document that I'm looking at. It says as to maintenance or what is called there is in this case, but now we're looking at a different case. So I'm trying to figure out how you say that that carries over to this case.
Though it's the same marriage, it's the same parties. Under the full faith and credit clause of the United States Constitution, we are, and under state be very, Washington is required to enforce and acknowledge orders of other states. And this is a final non-interlocutory order. So in the case law that I previously cited indicates that orders of legal separation remain in full force and effect, even regardless of the parties reconciling. So I think that Washington's required to enforce this order, and I think that it remains in full force and effect for an unlimited duration and addresses spouses for the parties. The case law that I'm referencing suggests that she needs to bring a petition to modify potentially, but this spousal support for the purpose of jurisdiction on the parties has been resolved.
And when you say a petition to modify, are you talking about the Oregon matter? Or are you talking about here?
She could do either. It's similar to like an entry of a parenting plan in Oregon. She could bring a petition to modify here, or she could bring a petition to modify there. But it is still an enforceable order. It would be a different situation if she had checked the box that it was a period of time, or she had sought to modify upon the alleged reconciliation. But that's not the facts of this case.
We believed we were married. We believed that we had checked the 2 years. We have been in a committed, intimate relationship for 28 years. And I have become totally 100% disabled since that was signed.
All right.
Oh, and I do not receive supplemental security income as stated in their declaration. I never have. I was denied because of my husband's income. I receive Social Security disability income.
So anything further?
No.
I would just note that the court's aware of this, but even if the parties were in a committed intimate relationship, spousal support cannot be ordered in those type of cases. So I think she's precluded from spousal support under either analysis.
So I did review the files and record. I did miss this one. I knew what it said, but I couldn't find it. That at this point, what the court's looking at is a procedural issue. And because of that procedural issue at this time, the court cannot order maintenance. And so at this point, maintenance is denied.
Okay. And
And I'm not even going to go into the need and ability. I think there are additional questions and issues that come up in regard to that. Access to the house. So, Ms. Gilmore, can you tell me, and I'll get to you in a minute, how much your client indicates she still has in the house?
And again, I would mainly have to rely on our previous declaration from our other motion where we submitted pictures. I think it's mainly has to do with a lot of like personal property items, toiletries, clothes, things like that, that I imagine she would want.
And that's something that he'd be willing to move into a storage unit? Okay.
Yes.
All right. So, you had something to say?
yes, he has already broken and damaged my personal belongings by just boxing them up. I was allowed to in the house 2 times since December because of needing the facilitation because of the restraining order or whatever it was. That's not on me. I got clothing and toiletries the 2 times I got to enter the house. I was not given enough time to move all of my belongings. And I would like to be the one to pack them up and move them as he has already damaged and destroyed my property.
And Your Honor, I can intervene. My client's happy to facilitate that. He can have his brother have her have access. That's not a problem. If she prefer to pack it up so we don't have to deal with any allegations back and forth, we're happy to do that.
Okay. All right. So I will go ahead and grant access. You'll need to work it out with Ms. Gilmore as to when. And I would go ahead and just allow 2 days again to come in for the timeframes that you did before. Get that worked out. And then we can go from there.
And do I need to be supervised by his brother during that time?
You do.
Fine.
And even though the protection order is off at this time, he has the right to possession of the house. I'm ordering that you would need to have somebody with you, being the brother. And quite frankly, it's better all around.
Okay.
And I would encourage everyone to take pictures and document what you do.
And he had offered to pay for that storage unit. Is that going to be?
So at this point, I'm not ordering the storage unit. I'm just having you go ahead and just go into the house and get your things.
Okay. And what do I do with, I'm living in a 200 square foot cabin.
Okay. Ms.
Your Honor,
Gill,
we'll be fine to pay the storage
Okay.
unit.
all right, so I'll go ahead and allow the storage unit. He'll pay for it. So you have a place to move your things into.
Okay.
Okay.
And there's also no order on who's supposed to pay my car payment?
Okay. I'm getting to that.
Okay.
Oh, the car payment?
Yes.
So in regard to the storage unit and the household expenses, those will be paid by the petitioner. You will need to pay your vehicle payments.
Okay.
Okay. All right. So let's go ahead and set presentation to June 11. Hopefully you'll have something figured out by then as to date and times.
And Your Honor, I'm fine preparing. I know it's her motion if she feels comfortable, whatever.
Okay.
Whatever the court would like to do.
So Ms. Gilmore will go ahead and prepare the order. And then we'll have presentation on the 11th. If you agree that it reflects what I ordered, you can sign off on it before, and then we can strike that hearing on June 11th.
Okay.
Okay. All right.
Thank you.
Oh, am I allowed within 500 feet of the home? Because that wasn't a motion. That was put on his declaration. He has not petitioned the court for that.
And I can just say, with my understanding of the order, she just doesn't access the house without an agreement and a third party. I think that that's sufficient. That's my understanding of the court's order. Is that correct?
Correct.
Okay.
Great.
So I didn't plan on adding any specific language about 500 feet.
Okay.
Also, all of my mail is still going there. I'm not in a permanent residence yet. How am I to obtain my mail?
So that's something that you should be able to change at the post office.
Right, but that's my permanent address. I'm staying at a temporary location.
Okay, Ms. Gilmore, I don't know if you have any thoughts.
A PO box, I don't know.
So
Okay, I'll
that's
figure it
probably a
out.
good idea, or someone that will receive your mail for you.
Okay,
Okay,
thank you.
all right.
Next, I have Timothy Fragel and Marcelia Fragel, 24-3-1208 is the cause number. Should have Ms. Gilmore representing Timothy Fragel.
Yes, Your Honor.
Okay, great. And then Marcelia Fragel, are you on the line? Okay, not hearing a response. We're on today for a presentation with Judge Hahn being absent. Ms. Gilmore, do you have a preference of, well, I'm assuming you submitted voters, correct?
I did, and I did speak with Ms. Fragel about the setup because I am aware she has an objection. I am fine with either the 2nd or the 9th. I indicated to her that I thought it would be in July, but I didn't specify, I can't speak, if it was the 2nd or the 9th.
Okay, so did I hear either the 2nd or the 9th would work okay?
Yes,
Okay, let's set up for July 2nd at 9 o'clock.
that works. Thank you.
Great, thanks so much.
Okay,
Okay.
all right.
Judge.
Yeah.
Judge.
Your Honor, I have a relatively short matter, I believe. This is Megan Gilmore.
Okay, just a second, Ms. Gilmore, and I'll take your matter. Apologize, you've had to wait. Let's see. What's your matter? Oh, here we go, 11 and 12, 24-3-00012-08.
And this matter is before the court on respondent's motion for contempt against my client. My client was not served until the 18th, which is roughly a week short of the timeline required. This is the 3rd motion within the last 4 months that hasn't been timely. Frankly, I normally just responded, but my schedule didn't allow me that opportunity and my client needs more time to respond. So we are asking the court to set over the contempt. We are also before the court on presentation, but we can potentially deal with that at the contempt hearing or now.
So, just want to make sure you're Marcella
Yes.
Fragel? Okay. Ms. Fragel is present in the courtroom, just so you know.
Your Honor, when I filed the papers, they told me.
Hold on, ma'am. In regard to the presentation,
I have objections to that, Your Honor.
okay. So you've heard me say this to other people, they need to be in writing prior to. So I think at this point, I'd rather just set both matters over, but you wanted to say something about filing?
Yes, when I filed the papers, they told me that I had to wait to get the judge's approval for the date. And the judge approved this date. As soon as I got that, I served it to Tim.
Okay. I understand that, but at the same time, there's still, you have to put in a date or have a date that's far enough out. You'll look at some orders that have alternative dates. If they're not served by here, here's what the date is. If they're not served by here, here's what the date is.
I understand that, Your Honor, but I was told to do it that way.
I get it, but unfortunately you were given some bad information.
Yeah.
So at this point, we need to go ahead and set this over. I'm looking at July 16. Does that work for you, ma'am?
I'm looking. No, I have a doctor's appointment that day.
July 23
That's fine.
is more.
That works for me.
All right, I'll go ahead and set this over to July 23rd.
And what am I to do about my safety issues until then?
I can't give you any legal advice. You can talk to an attorney.
And Your Honor, I imagine my client will appear regardless, but can we waive his appearance if he does need to work, given the fact that we've been here so long today?
Now, I think he needs to appear.
Okay, thank you.
Number 10 on the docket, Fragel and Fragel, 24-3-00012-08.
That matter's ready, Your Honor.
All right, this is your motion. Go ahead.
I'm sorry, which motion is it? We have two on the docket.
Whichever you want to proceed with.
Okay. I've got the declaration of proof of service for my objections to the presentation of orders that Ms. Gilmore wrote.
Okay, I haven't seen them. Did you file them?
Filed them.
Did you file your objections?
Yes, I did 3 weeks ago.
Do you have a date in particular?
Yes, I do.
It looks like it was filed on July 15th, Your Honor. That's helpful. It's the last declaration.
Yeah,
Okay, I do have it. Let's go ahead and address the order first.
okay.
Hold on just a minute. Okay, go ahead.
I listed everything out in my declaration. I don't have any more to add.
All right, Ms. Gilmore.
If Your Honor recalls, if you look back to the minutes, the court specifically didn't order my client to pay for the storage unit. My client stipulated to that to avoid additional motion. At the time that we did stipulate to that, the storage unit was in Woodland, and it was a certain size and a certain amount. Wife wanted the storage unit to be moved to Salmon Creek. My client stipulated to that even and helped her move, again, because it was comparable price. Then she asked to have a bigger storage unit, which my client again helped her move over, but indicated to her that he wasn't going to stipulate to ongoing temporary orders to that effect, given it was substantially more. So the agreement that we previously stipulated to has since changed. So it's our position that we either ask for a date certain to end that, which is September 1st, or alternatively, my client should only be paying the amount that he paid at the Woodland storage unit, which we stipulated to at the previous hearing.
That was never stipulated to, Your Honor.
Oh, hold on, let her finish. Okay.
That's it, Your Honor. This situation has simply changed. My client was trying to be flexible and amicable. He just simply can't pay for an extremely large storage unit without a date certain. So again, it's our position that we have a date certain, i.e. September, or that he only pay the portion that he paid with the Woodland storage unit, again, based on that stipulation that we represented to the court at the last hearing.
All right, so in regard to the, let me get back to that proposed order, just a second. So in regard to the proposed order, Ms. Gilmore, I'm going to adopt her proposed order that was filed.
Does Your Honor have a bench copy of that?
I don't.
I'm sorry, which?
Let me go back and find it.
It's been said over several times, so I imagine it got lost.
6/7/24 it was filed.
I can have my staff create a new order with your attention, Your Honor.
All right, so Ms. Fragel, that's the order of the court. Are you okay to put approved
I
on
don't
it?
understand what you ordered.
You can see a copy of the order then. I approved what the proposed order is from Ms. Gilmore, which is filed on June 7, 24.
That he only has to pay for it through September 1st.
Correct.
Yes, it's fine.
Okay, she's approved that, so put that on the order and just send it to me for signature.
Understood.
Oh, I didn't approve that. I said it was okay to put that I appeared via Zoom.
Okay, apparently she doesn't approve
I
it. She
do
puts
not.
appeared via courtroom.
Understood.
All right, then the other motion.
And it's my motion for contempt for unpaid child support, Your Honor.
Go ahead.
I put it all in my thing again. I would like to be on record though. According to our legal separation dated June 18th, 2008, Timothy was to begin paying child support on September 1st, which stated $435 for 2 children per month. I did not ask for any adjustments in the last 20 years, even though I became 100% totally disabled, and Tim grosses 10 times the amount I do. I've calculated for each child based on the numbers from 2008. And I believe because he never made a payment, not one payment, that money goes to me for what I did to support our children. He never paid.
Anything else?
I had the numbers, the date it was served, and the order to go to court.
Gilmore?
Your Honor, I'll keep it brief. I know you have a long docket. This simply is a very clearly not a willful intentional violation of the Oregon order. Wife brings this motion in clear retaliation of our last motion, some 6 years after the youngest child turned 18. In reality, my client provided support to these children, all of the support for these children as set forth within these now adult children's declarations that were presented in reply. Not only has he provided support for the children as the children lived with him, he also provided support to wife. I think that it's very clear from her failure to provide a reply that she's acknowledging that my client not only provided her transfer payments of support in the way of giving her money, but also he paid $75,000 of her debt. He gave her $50,000 of his Powerball winnings. Then she also fraudulently took over $15,000 of credit card debt. I understand that this is a complicated case, given the fact that the parties did have a legal separation in 2008, but there simply isn't a willful intentional violation of a court order. And I think if anything, this needs to be reserved for trial to address if there's anything owed, because I think that my client can provide testimony that simply there isn't anything owed, as well as if we need to, these children can testify based on their personal knowledge that they were supported by my client as well as wife.
At 7 years old, they can testify to that. Ms. Gilmore?
I'm sorry,
Stop.
Oh, sorry.
I didn't hear what she said.
I never got a
Never mind.
response at all.
Okay. And then I would just like to note, I apologize, Your Honor. I would just like to note that this is the 4th motion since February. My client has paid $8,000 in over $8,000 in attorney's fees, fighting motion after motion. I appreciate the fact that she's a pro se litigant. We just, again, I believe that this motion was brought in bad faith and we ask the court deny it.
Your Honor, the amount he's paid in attorney's fees have nothing to do with this case, except for the fact that he says he can't afford to eat. And yet he's paying attorney's fees. Mr. Fragel willfully did not file or follow the court order. None of the rest of that makes any difference. He willfully did not follow this order. I am asking the court, since you've already ruled on the 2008 legal separation and given him allowances for that you do the same for me.
So here's what, when I reviewed the documents, that I don't know when you're set for trial or if
We
you're
are.
set, you aren't yet,
Nope.
then probably needs to get moving forward.
Yeah.
But meanwhile, I want to reserve this for trial. There are a lot of issues that were brought up. Ms. Gilmore, she indicated she did not receive your response.
I haven't received any.
That was mailed to her. We have a certificate of service to the address. Hold on, I can confirm.
Your Honor, I would request it.
Okay, I'm listening to Ms. Gilmore at the moment.
It looks like we served her that Ridgefield address on July 9th, so some 2 weeks ago.
So I think that would be another reason to reserve it for trials. You haven't seen their response or the responses because there were responses from your adult children.
Okay.
So
Can I ask that it be a signature required? Delivery by
they
mail?
need to follow the law that's required, and I'm not going to order additional requirements.
So it doesn't matter that I didn't receive it,
Well,
or
you,
they didn't send
at this
it?
point, I'm not proceeding forward. You can address it further at the time of
I
trial.
understand, thank you. Can I ask the trial be soon and that it be scheduled? Because she hasn't even scheduled the trial.
Okay. You can do it too.
Oh.
You set it on a trial assignment docket for scheduling.
Thank you.
Okay.
I will do that.
All right, Fragel, oops. Fragel and Fragel, cause number 24-3-00012-08. I have Renee. Is it Fragel? Am I saying that correctly? All right. All right, and Ms. Gilmore, I've read the motion. Ms. Fragel, anything you wanted to add?
Yes, Your Honor. I did not have time to respond to their response because I received it Thursday. So I would like to point out that RCW 4.72.080 does give you the authority by saying when after the entry of a judgment, either party fails to fulfill the terms and conditions on which the consent judgment was entered. I have lined out in all of my paperwork how we did not fulfill the terms and conditions. And that allows the court to negate the 1-year rule.
Anything else?
I don't believe so, Your Honor.
All right, Ms. Gilmore?
Your Honor, I was just pulling up the proof of service. I think my staff sent that over 2 weeks ago on what looks like September 9th. So I'm surprised by her just receiving it. If the court wants to entertain a set over, that's fine.
There was
but
one
I
that
don't.
you sent that never arrived as well.
Ms. Fragel, please
Yes.
don't talk over her.
Oh, I'm sorry, I apologize.
Gilmore, what were you
So
saying?
I'm fine with a set over if she would like to provide additional response. I don't think it's necessary at this point. My memorandum is pretty clear. I don't think CR 60 or 59 applies in a case where an Oregon order was entered over 16 years ago. I can cite some of the case law, but I think that again, it's straightforward. So I'll defer to the court if you have any questions for me.
Ms. Fragel, I want to make sure you have an opportunity to be heard. Do you want to set it over to respond to their?
No, Your Honor, I responded with the RCW. Do I need to put that in writing?
Yeah, that's fine. You're fine. Ms. Gilmore?
Sorry, did you need something else from me?
Go ahead. Anything you wanted to add?
No, Your Honor.
All right. Any argument, Ms. Gilmore?
I'm happy to present argument, Your Honor. I cited it. Did you see my memorandum?
I did. I apologize. I wanted to make sure everyone knew what I was talking about. We go ahead. I didn't know if there was anything more you wanted to add. Sounds like you don't, but just want to make sure.
Not necessarily. Again, I think that she's barred under CR 61 1 through 3, given there's a clear 1-year timeline. The others from 4 to 11 say reasonable timeline. I would say under any definition of reasonableness, trying to vacate an Oregon order that's 16 years old isn't reasonable. Again, I provided case law that reconciliation doesn't invalidate decrees of legal separation. That's still good case law. A change to the parties' financial situations will not justify application of CR 6011. So frankly, I just don't think that there's any basis for us to be here today. This is I want to say 4th or 5th motion that we've been before the court since the spring of this year. So I am asking the court to enter an order prohibiting abusive use of litigation in this case.
Ms. Fragel?
Yes, she actually wrote out
You
what my
talk about
motions
just a
were.
bit. I can't quite hear you.
Okay, how's that?
Better.
Okay, so Ms. Gilmore pointed out my motions, and they all have basis in law. And when he was taking my things and breaking them and putting them outside, you entered leaving respondent's property alone, that he has not done. So I don't understand how I can be considered abusive litigation when he is not following court orders and I have to bring him back to make sure he does.
Anything else?
No, ma'am.
All right. So I did review the files and record, including the memorandum of law and familiar with the statute that was indicated. But based on that, the court does deny the motion to vacate the order. More specifically, the parties entered a general judgment of separation on June 18, 2008. Under CR 60, the motion is to be brought within a reasonable time and for certain basis under 60B 1 through 11, within 1 year after the judgment order or proceedings was entered or taken. We are way beyond that, and even if not, there is no showing of any of the identified sections as a basis to vacate. There is no showing under rule or case law to vacate the general judgment of separation, so the motion is denied. So with that, I don't have an order to sign in regard to the I'm not going to order the litigation request at this time. May if it continues, but at this point, I'm not going to. But Ms. Gilmore, do you want to prepare an order, or Ms. Fragel, do you have an order? I didn't see one.
No, Your Honor, I did not turn one in. I've got it with me.
I'm happy to do an order if the court would like me to make findings. Alternatively, the court, I'm happy to also just do a bench order, the court doing a bench order saying it's just simply denied, whatever you prefer.
All right, I'll just do a bench order, Ms. Fragel, which is something I just write up. So it's taken care of. Okay.
Okay.
All right.
And then can we move on to the next part?
The next part being, what are you talking?
The response to the 7-9 declarations. And specifically the fact that I have a notice of entry of judgment, including a judgment lien for him to pay child support. If we are going by the 2008 order,
Ms. Fragel,
I need to turn
Ms.
this
Fragel,
in.
stop. That's not on today's docket. It was not.
It is.
At all.
I can show you right here. It is on the docket, right there.
Okay, well, it's not showing on my docket, so I did not prepare for it.
Well,
I think what's
Go ahead.
I think what's happening is the last time we were before the court reserved the issue of back child support for trial. I believe what she's trying to do is reconsider that ruling or provide more information on it.
Well, it's not before me. Ms. Fragel, it's not before me. I won't be ruling on it. I've already ruled on it.
As far as I understand, you don't need to, because I already have the judgment and the order and the lien paperwork.
That's up to you to do it, but I'm not making any further rulings on it.
Okay, that's fine. It's already been ruled on, Your Honor.
All right, that concludes that matter.